Yes. May it please the court, I appear on behalf of the appellant. My learned friend, Mr. Brady, appears on behalf of the second respondent. The first respondent is not present or represented.
Yes, they've sent a letter to the court.
They have, my lord.
Yes.
I'm grateful for your lordship's indication that your lordships had cited that letter.
Yes. Yeah.
If I may just check as a matter of housekeeping, your lordships will hopefully have a copy of my skeleton argument running to some 11 pages.
Yes.
A copy of my learned friend's skeleton argument running to 18 pages without the back sheet.
Yes.
Then there is the core bundle, which runs to 116 pages.
116, yes.
Now, just in relation to that core bundle, my lord, it came to my notice on reviewing the bundle that the order of Mrs. Justice McGowan was missing from that. I've taken the liberty of printing out hard copies of that order.
Yes.
My learned friend has no objection to that being handed up.
Thank you.
And I've taken the liberty of labelling it 117 and 118. So I'd be grateful if your lordships would kindly add it to the back of the bundle. I don't intend troubling your lordships with the order itself, but just as a matter of completeness, making sure that it's
thank you.
To assist the court if needed. And then there's a replacement authorities bundle. This runs to 146 pages, 146.
Yes.
And finally, there's been some correspondence your lordship may have had cited in relation to the High Court bundle, and that being available to this court. The position with that, I'm sure I'll be corrected by my learned friend if I inadvertently misrepresent the position, is there was correspondence from those instructing my learned friend seeking that it be placed before your lordships, and a request was made for it to be passed from the High Court to the Court of Appeal. It then transpired fairly recently that obviously isn't the normal practice of the court, and I understand from those instructing my learned friend that a copy of the High Court bundle is available if your lordships wish to be taken to any particular page in it, and I have another hard copy of it as well in court if necessary. I don't intend to trouble your lordships with any part of that bundle, but I have no objection to my learned friend if my learned friend wishes to draw your lordship's attention to any particular page in that bundle. I have no
Well, should we see how we go?
I'm most grateful, my lord. Would it assist your lordships if I went through some of the background facts of this matter?
Well, briefly, yes.
Very, very briefly, if I may. Essentially, there was an agreement signed between Mr. XXX Elo and the second respondent.
How do you pronounce it?
I don't actually know, my lord. I've always gone with XXXX and then just called him Mr. Elo after that. That agreement effectively was breached by Mr. Elo. Proceedings were brought by the second respondent, and effectively there was a fairly extensive litigation thereafter, but some endpoint of that litigation is that a judgment against Mr. Elo failed to be set aside, and the appeal against that, permission for an appeal against that was dismissed. Following that, the second respondent instructed Marston Holdings Limited, a High Court enforcement officers, and they seized 8 vehicles. Those 8 vehicles are particularized in the particulars of claim but also appear, in fact, I'll give you lordships, if I may, the particulars of claim reference. It's page 113 of the bundle. It's paragraph 7 of the particulars of claim. But essentially, they were somewhat unusual vehicles. They included a Batmobile, a 1966 Volkswagen Beetle Herbie replica, a 1976 Mr Bean Mini, and in total of those 8 vehicles, 5 were unique and 3 were very rare, Mr Elo being in the business of movie vehicles. The issue with the seizure of the vehicles is that the position of my client, Elo Trustees Ltd, is that the vehicles belonged, and they were the registered keepers, belonged to Elo Trustees Ltd rather than Mr Elo. And that they had effectively, the second respondent had mounted a coup de main in seeking to seize those 8 vehicles. There is obviously a link between Mr Elo and Elo Trustees Ltd. The clue's partly in the name. He's the director of Elo Trustees Ltd, and he's filed an affidavit which he says he has 80% of the shares in Elo Trustees Ltd. But as a matter of law, my lord, they are 2 separate legal entities, Mr Elo being one and Elo Trustees Ltd being a second. And the position of both Mr Elo and Elo Trustees Ltd is that the vehicles belonged to the company and not to Mr Elo. And that key important piece of information partly explains, in my submission, part of the reason why this set-aside application has been resisted so strenuously by those instructing the learned friend. I'll return to Bonhams in a moment, because effectively this is their chance, and I term it in fairly pejorative terms, this is their chance to knock out the claim brought by Elo Trustees Ltd to recover the vehicles, and effectively grab hold of 8 vehicles that Elo Trustees says belongs to Elo Trustees and not to Mr Elo. Moving forward in time, Bonhams, the first respondent...
when were the cars seized?
Pardon, my lord?
When were the cars seized?
The cars were seized in...
Because there was a previous application which wasn't issued. So the cars must have been seized before mid-21.
Before the 15th of March 2021, my lord. I don't have the exact date to hand. I can look during a brief intermission for a date when those cars were seized, but it was certainly before March 2021. Bonhams were instructed to sell the vehicles. Bonhams, the full name is Bonhams 1793 Limited, but I'll refer to them, if I may, my lord, as Bonhams. Placed the vehicles for auction. And they were again listed for auction the appellant learnt of that on the 7th of April 2022. It may be thought slightly surprising that Bonhams would entertain auctioning vehicles which were the subject of a live dispute as to their ownership, but suffice to say Bonhams didn't back down, and an application was made against Bonhams on the 11th of April 2022.
There wasn't a dispute at that stage. Was there?
Not a dispute in court, my lord, but certainly a dispute between HNW, the second respondent, and Elo Trustees Ltd as to the ownership of the vehicles. On the 13th of April 2022, your lordship's brother judge,
So what had happened between March and April 22? From the point of view of, sorry, March 21 and April 22.
Well, effectively what happened, my lord, was the application was filed, but it was not issued by the court. And obviously it was a COVID period of time. I make no criticism of the court in any way whatsoever, but I obviously concede that matters slid somewhat in that period of time between March 2021 and April 2022. I don't seek to
right.
And there's no evidence of any other formalisation of this dispute during that period.
Well, there's correspondence, my lord.
Where is it?
It's not in the bundle, but effectively, H&W were on notice that, and Marston were on notice that the ownership of the vehicles was being asserted by Elo Trustees Ltd. So on the 13th of April 2022, Mr. Justice Foxton made the order granting my client's application for an injunction, and the order contained various unless orders with 3 operative deadlines. The first was that the claim be issued by midday of the following day. The second is that it be served by the 20th of April 2022. And the third is that evidence in support of the application be served by the 27th of April 2022. And what I've described in my skeleton as the Foxton order is a copy of that is on page 76 of the bundle, my lord.
Yes.
Suffice to say that the 3 deadlines were missed by a matter of days rather than weeks or months, but they were missed. And the unless provision then obviously kicked in. Those instructing my learned friend, in fact, I'll retract that, it may have been the first respondent, but one of the respondents then belts and braces applied on the 4th of May for an order effectively confirming the unless provisions, and that was granted by Mrs. Justice McGowan on the 5th of May without a hearing. And that's the order which I've just handed up, my lords.
Yes.
What followed then was an application for relief from sanctions and an application to set aside the order of the 5th of May. The application for relief from sanctions was filed on the 2nd of May 2022 and was issued some 6 weeks later in mid-June.
Can you just help on that? That is the application at page
72, my lord.
72.
Yes, apologies. That's actually got a stamp of the 2nd of May 2022 on it. It was only provided some 6 weeks later in the middle of June. So I appreciate that the court seal has the 2nd of May, but it was only served by the court some 6 weeks later.
So it wasn't sealed 6 weeks later, it was sealed.
Apologies, yes. My lord.
And the intention was that it would be served by your client.
Correct, my lord.
And as far as I'm aware, there is no evidence of any attempt to chase up between the 2nd of May and 6 weeks later.
Again, I'll check the correspondence, my lord. I appreciate there's nothing in the bundle.
There's nothing in the bundle that I've got.
Yes. That application obviously crossed with one of the respondents' application dated the 4th of May. They were not on notice of the 2nd of May application, no criticism of them in that respect at all. And then there was the second application to set aside the order, the McGowan order. That was made on the 22nd of May, 2022. Mr. Charles Bagot, then Queen's Counsel, now King's Counsel, heard the hearing of those applications, sitting as a Deputy High Court Judge on the 25th of July 2022 and dismissed both applications. My Lords, in my submission, there are 4 key issues, legal issues that arise in this appeal. The first 2 main issues is firstly whether personal service can rebut the deemed date or not.
Well, you need to be clear in making that submission as to personal service of what, because the rules differ for claim form and other documents. So it's not in dispute as far as the claim form is concerned. It's deemed service 2 days after, whether you do it by post or personally. But of course, when it comes to the evidence that was required to be served, the rule is different, because their personal service will be effective on the day of service.
Your Lordship is of course absolutely right, and it's in relation to the claim form rather than the other evidence. And that does appear to be common ground between myself and my learned friend. He, in my view, quite rightly concedes in his skeleton argument that the personal service cannot rebut the deemed date for service of the claim form. The second issue is potentially the more interesting issue, my Lords, and that is the definition of the word promptly. And given how regularly the issue of promptly arises in county courts and high courts up and down England and Wales, it would probably be of great assistance to practitioners for this court to assist by giving some guidance, or more detailed guidance, as to how to construe promptly or approach promptly. And your Lordships may have seen the approach taken by the learned judge in the court below, which is effectively to, and I'm paraphrasing what his Lordship found, but effectively to say, because the time scale for compliance is tight, therefore the construction of the word promptly, or the application of the word promptly, is tight as well, with the inference being that if, for example, the timeline for compliance had been a month or 3 months, then promptly, the approach to the word promptly might be taken in a slightly different way. And the reason why this is potentially of interest to practitioners is because it is a factor that is prayed in aid on a regular basis in courts across England and Wales. And it is, in my respectful submission, an important factor because it can be the balancing factor. And if the judge falls into error by finding, for example, that something filed within 5 days is not prompt, that is a factor which the judge then in error takes as being a factor in pointing in the wrong direction rather than potentially in the right direction. So the second key issue is the word promptly and what approach this court has taken previously to the word promptly. And I'll attempt to assist your Lordships with reviewing some of that case law. And then the third and the fourth issues are fairly softer issues. And that is essentially the judge's approach to the appellant's failure to serve an unsealed copy of the application and the appellant's failure to correspond with the court. And that's in relation to the Mr XXXX Elo terminology, and essentially his lordship in the court below was intimating that the appellant should have anticipated that there would be difficulty with that first name, and the court may well decline to issue the claim form on that basis, and should have anticipated that, and should have written to the court to say, yes, this is my real name. In terms of the third and fourth issues, I'll take your lordship to what, certainly on the third issue, is what assistance I've been able to glean as to the significance of an unsealed, in that case, an unsealed claim form. But again, it would be no doubt of assistance to practitioners for your lordships to assist and give some indication as to what expectation there is on those conducting litigation to firstly serve unsealed copies of application notices, and secondly to correspond in anticipation of expected difficulties with litigation or issuing court documents. So those are the four main issues. I'd hate it to be thought that I've unnecessarily narrowed the four issues, and your lordships may well feel that there are other issues involved as well. But I will also return, if I may, to some of the statements made in Denton and White about the approach to contested relief from sanctions applications, and I'll conclude my submissions by drawing your lordship's attention to what this court has said in that regard, my lord.
So I don't want to divert you from your course at all, but just so as I can put your four key issues into context, can you just assist us briefly by just giving us an intimation of what your answer to a key point made by Mr Brayley in his skeleton argument is? Because what Mr Brayley points out is that in this case there were not just one or two, but three breaches of the unless orders in Mr Justice Foxton's order. And whatever might be said about the breach with regard to issue, and whatever might be said about the breach with regard to service of the claim form, none of that detracts from the fact that there was also a breach with regard to the timing of service of the evidence. And so the point is made, well, even if there was some flaw in the way the judge dealt with the first two questions, that doesn't impeach his decision with regard to the third breach, which he addressed individually as well as cumulatively.
Well, my lord, and of course my learned friend is quite right to make those points. Those are all points well made. If I could respond in turn to elements of those points. Yes.
I'm not expecting a full response, just as it were a headline of where you're going.
Well, I can perhaps sail between a full response and a headline. The first point is essentially that his lordship says, well, this is part of a pattern of breaches. Essentially, that's my learned friend's point. And look at this series of breaches. And of course, that, in my respectful submission, it is at its highest a mischaracterization. At the worst, this is a single breach of the witness evidence. So that's my first response to that, my lord. My second response is that ties into the promptly question. looking at the issue of promptly, His Lordship has essentially said that these were not prompt applications and effectively added a stone to the cairn, whereas in my submission, that they were prompt, and that instead of being a stone added to the cairn, should have been a stone removed from the cairn. So the cairn was too big in the first place because there are 3 breaches, and secondly, the learned judge adopted, in my submission, the incorrect approach to the issue of promptness. So I can return to that in due course.
All right, well, that's a helpful indication, thank you.
If I may turn to the first issue, the personal service issue, and I can probably glide over this fairly quickly, my lords. This is CPR Rule 6.14. It's on page 248 of the current version of the White Book. I'll read it out in fuller claim forms.
Well, do we need to get into this, given it's common ground?
Effectively not, my lord. And I've provided the 2 Court of Appeal cases, one from Godwin and Swindon Borough Council. The relevant paragraphs are paragraph 13 of my skeleton argument, and then that was effectively followed by Your Lordship's brother judge, Lord Justice Mummery and Anderton and Hewitt, County Council number 2. And again, I've inserted the relevant paragraphs in paragraph 14 of my skeleton argument.
Yeah. And when it comes to other documents, the operative rule is 6.26,
Correct.
which says that if there's personal service, it's immediately effective.
Indeed, Your Lordship, it is absolutely correct. So that's ground 1. And unless Your Lordships wish me to assist any further in relation to ground 1, I can move on to ground 2.
Yes, thank you.
So ground 2, as I indicated, is potentially the more interesting ground, and this is about the issue of the word promptly. What does promptly actually mean? And if I could invite Your Lordships to turn to the authorities bundle, and page 64, 64. This is the case of Regency Rolls Limited and Arnold, 2000 England and Wales Court of Appeal Civil Division, case number 379. Effectively, my lords, it concerned a application to set aside an order made by the court on preliminary issues relating to whether Mr. Arnold was a director of a company or not. At the resumed trial, Mr. Arnold didn't attend. The judge refused to adjourn. He didn't consider, the learned judge didn't consider the medical evidence sufficient. Mr. Arnold then dispensed with the services of his then solicitors, instructed new solicitors, and the judge's order was the 22nd of March. That appears to have served on the 27th of March, and by the 21st of April, an application to set aside was issued. So it's just shy of 1 month. And the learned circuit judge did not set aside the judgment aside because of lack of promptness in making the application and lack of reasonable success. In the judgment of, as she then was, Lady Justice Arden, so this is page 69, my lords, of the authorities Bible.
Yes.
Her ladyship, in fact, dismissed the appeal on the basis of no reasonable grounds of success, but her ladyship did turn to the issue of promptness in paragraph 24. And her ladyship refers to counsel for the appellant in the second line. Mr. Stafford began his submissions by saying that promptness was a flexible concept. Obviously, there's a link to my submission a moment ago about the approach of the learned judge in the court below as to how flexible a concept promptness is. But Her Ladyship goes on to say, I think a note of caution should be struck here. The dictionary meaning of promptly is with alacrity. I have grave doubts as to whether Mr. Carnell acted with the requisite degree of alacrity. But in view of my conclusion on other matters, I need not decide this point. So that appears to be obiter, clearly obiter from a judge of the Court of Appeal. So clearly obiter, that carries some weight. But in my submission, there are two key elements there. The first key element is that there isn't a notion of flexibility in promptly. The second is that Her Ladyship appears to warm to a definition of with alacrity.
But even that's elastic.
Alacrity.
Yes, what may count as alacrity, if you've got a week to do it in, may be different from if you've got 24 hours to do something. And one of your problems here is complete absence of any, like a bit of jumping up and down, when you knew you were under an unless order. Could you just help me on this? Does the fact that the order, Mr. Justice Foxton's order, was an unless order itself have relevance to the significance of breach? Because you can have any number of orders short of an unless order, and you can have unless orders which don't strike out your claim. And it seems to me that when looking at concepts such as promptly or reasonable excuse, the nature of the order that's being breached is itself relevant. Would you accept that?
Yes, and if I can expand your Lordship's observation, if I may, a common misconception is that a relief from sanctions means application needs to be made whenever a deadline is missed. In fact, a relief from sanctions, the clue is in the name, relief from sanctions is relief from sanction. So if there is the oft-quoted example is in Part 32 with a witness statement. There is a sanction. And adopting your Lordship's approach with an unless order, there is a sanction with an unless order. So that is clearly relevant as to whether a relief from sanctions application has to be made or not. The second point, if I may, is what bearing that has on promptly. In my respectful submission, that doesn't have a bearing on promptly. The promptly is the action taken after the breach. How prompt is that action, rather than the severity of the breach. My third point, if I may, is that the significance of the unless order is that it is very draconian. In the words of, using the terminology of Denton and White, the respondent, the second respondent, gains a windfall from an unless order, and that feeds into the third limb of Denton. Is it just in all the circumstances? This isn't a case of a trial date being placed at risk or one of a number of witnesses not being permitted to give evidence. This is a case that the claim comes to an end.
This isn't a windfall. This is a consequence of your previous conduct. So the only sense in which you can describe as a windfall is that you don't have a trial on the merits. That's the same with a default judgment. It's the same with any number of procedural steps which may lead to the loss of a claim. It's not a windfall.
And that is why in the third limb of Denton, is it just in all circumstances, the repercussions or the implication of refusal to grant relief does weigh in the mix of whether it is just, because this isn't merely a sanction which will fetter a claimant. It is a sanction which will effectively, as your Lordship quite rightly says, stop the claim in its tracks. That is the end of the claim.
Could have appealed the Foxton order.
No, your Lordship is quite right. The Foxton order was not appealed, and the approach that was taken was to apply to set aside the McGowan order and apply for relief from sanctions, and obviously with the benefit of hindsight, surety being double sure, an appeal against the Foxton order out of time would have perhaps not been
or an application for an extension of time.
Absolutely, and that point was made by the learned judge, and I accept the learned judge's observations in that regard. But in my respectful submission, those are factors towards the grant of relief or not, rather than a knockout point as such. Returning to the issue of promptly, so paragraph 24. Sorry, yes.
I'm very sorry for interrupting my learned friend, but on your point, my lord, about appealing the Foxton J order, that order I understood was agreed by consent of the parties present at court. The appellant represented by Damien Falkowski at that time. I understand he had cited the draft order, so it's one of the points that came up before, just very KC is now, was the fact that he consented to that timetable, and as a result knew what needed to be done, and presumably under the impression that it could be achieved. So I say that as relevant because that would explain why there was no appeal to it, because it was essentially almost by consent.
Does the judge deal with that in his judgment?
Yes, he does. I think he does.
He does, my lord, and I can take your lordship to the relevant paragraph if needed. Effectively, my learned friend is right. That order was agreed. I'd understood your lordship's question as effectively a late appeal when it became apparent that those deadlines had been missed, an appeal on the basis that the deadlines were too short. But
well, it being by consent makes an appeal much more difficult.
Absolutely.
But it doesn't preclude an application to either to Mr. Justice Foxton or to another judge to extend time.
No, your lordship is absolutely right, and that was not done. What was done was an application to set aside, and that was the view that was taken at that point. I'm grateful to my learned friend. I didn't want to essentially draw your lordships into too much detail around that issue, but I'm grateful to him for his intervention. So that was Lady Justice Arnold's approach to promptly, which, as I pointed out, is overturned. And then if I could invite your lordships to turn up page 72.
Yes.
This is Lord Justice Simon Brown's judgment.
Yes.
And then page 73, paragraph 45,
yes,
is what his lordship says about promptly. Second line down, he says, at first blush it might be thought that any inappropriate delay, whatever on the part of the applicant, would require that he be found not to have acted promptly, and then goes on to say, yet such a construction would carry with it the draconian consequence that even if he had a good, perhaps compelling reason for not having attended the trial, and reasonable, perhaps indeed excellent prospect of success at trial, the court would still be bound to refuse the trial. I would accordingly construe promptly here to require not that an applicant has been guilty of no needless delay whatever, but rather that he has acted with all reasonable celerity in the circumstances. And that appears to be the current state of the law in relation to the approach to promptly, acted with all reasonable celerity in the circumstances, and his lordship went on to say 30 days was altogether too long a delay before making this Part 39 application. In this case, the delay appears to be 5 and 12 days. The learned judge held that that was not prompt, and I would respectfully invite your lordships to find that that was prompt and was acting with
so it's a decision, you would say that the approach is settled, that it's reasonable celerity in the circumstances. and it's for the trial judge to determine whether, just looking at this very narrow point, whether a party has acted with reasonable celerity in the circumstances. So is your submission that the judge was not entitled to come to the conclusion that the appellant had not acted with reasonable celerity, and if so, on what basis do you make that submission?
Well, my lord, it's on the basis that 5 and 12 days is all reasonable celerity in the circumstances and was prompt. And I appreciate your lordship says, well, that effectively falls within judicial discretion. But if the trial judge goes, well, a delay of 30 minutes is not acting with all reasonable celerity in the circumstances, that at some point they're
So the submission is, it's a decision which no judge could reasonably have come to.
Essentially, it's Wensbury unreasonable, irrational, perverse, a delay, describing a delay of 5 days as not being prompt.
No material upon which they could reach that conclusion.
Essentially, my lord.
Thank you. So do we need to deal more with the definition of prompt?
Well, my lord, again, I appreciate your lordship has invited me to say, well that's essentially an exercise of the judge's discretion.
No, about you
Yes.
were portraying this appeal as raising significant legal issues of concern. Well, you seem to be saying that what is set out in paragraph 45, I don't know whether it's referred to in the White Book or not, but has stood the test of time since 2000. I'm sort of wondering why we need interfere with it or expand on it.
Well, it's to effectively assist practitioners, because the delay, not the delay, the issue that arises in courts repeatedly is how many days is considered prompt and is not considered prompt.
So if you were putting forward an alternative exposition of what promptness means to what is set out in Regency roles, in either formulation, what would it be?
Well, in my respectful submission, it would be 14 days, my lord, because
Sorry, 14 days what? No, I'm talking about the legal approach.
yes, my lord.
So what, 14 days in any circumstances?
Well,
I
yes,
don't understand.
effectively, because what happens is practitioners pick up the White Book. Your lordship will be very familiar with this. Pick up the White Book and will look in the notes and say, what approach, in terms of legal certainty, what approach is the judge likely to take as to the delay here? And at the moment, what there is in the White Book is 30 days is too long, and that comes from essentially Regency roles. But the grey area in between, that chews up a lot of litigation time and court resource and gives rise to litigation uncertainty, is effectively where parties are not clear.
Right, so your submission is that in place of reasonable celerity in the circumstances, we should say 14 days.
Essentially, my lord, it would be of great assistance to practitioners. And in my submission, for practitioners to say, well, here is legal certainty. If you're within the 14 days, that is prompt. If you're not within 14 days, that's not prompt.
I'm rather bemused as to how we could do that. Set down such a rigid rule, which might, you think, require the rules to consider rather than the court randomly to identify 14 days, as in all circumstances, constituting promptness.
Well, firstly, my lord, I appreciate that there is a dead ground between the CPRC and the courts. The CPRC is obviously black letter law in terms of being a statutory instrument and what the CPR says. But where this court in particular is of considerable assistance to lower courts is by assisting lower courts by saying, well, how should an approach be taken to the rules? And the difficulty at the moment in the lower courts is precisely the difficulty that arose in this case, which is one party is considering 5 days being prompt, the other party is inviting the judge to say 5 days is not prompt. And that litigation uncertainty drives applications being made, prevents parties taking a view of what is the certainty, or what is the likelihood that a judge will take when approaching the word prompt.
Okay, thank you.
And I appreciate your lordship indicated that matters have been undisturbed for 20 years. But that's not to say that High Court judges and County Court judges, busy County Court judges with press lists, would not be assisted by further guidance from this court as to the correct legal approach to take to the word promptly.
If we adopt an arbitrary 14 days, then, for example, on the facts of this case, when you know that you're in breach of deadline for the service of claim form, you've got 14 days despite the fact that you're meant to serve your evidence within 7 days. So how does that work? You just battle on regardless.
Well, not necessarily, and in this case, the application was made 5 days after that. So I appreciate your lordship is drawing the distinction between the time.
It's 5 days after the date upon which you were meant to serve evidence.
Oh, sorry. Yes, my apologies, my lord.
The point I was pursuing was if you take an arbitrary 14 days, which does not take account of in the circumstances from Lord Justice Simon Brown's approach, you automatically damage the rest of the unless ordered timetable.
And this goes back to that concept of flexibility and promptly and the approach of Lady Justice Arnold.
Which you reject?
Essentially, yes. Firstly, on the basis that that's obiter, and secondly, on the basis that what doesn't assist parties is a lack of litigation certainty. So litigation thrives when there is litigation uncertainty.
Well, why not 3 days? I might be tempted by 3 days.
You'll look at. I'm sorry.
It's arbitrary.
There are many, many areas where judges have to exercise discretion. And this is one of them. Right, okay, but I think we've understood your submission.
Thank you, my lord. So the two final issues are I've described as the duty on the appellant to provide an unsealed copy of the application to respondents, and a duty on the appellant to correspond with the court to explain the appellant's unusual name. Now, perhaps...
Can you just remind me, where does the judge, which parts of the judgment are you challenging under these two headings?
I'll find the references for your lordship now.
And I've seen the consenting or agree was paragraph 14 of the judgment.
I'm grateful, my lord. So page 48, paragraph 62.
48.
Yeah. Paragraph 62, second line, the claimant took no steps to provide the unsealed application to the defendants.
Right.
The paragraph 22, I'm grateful to my learned friend. It's page 40. So the first two lines concern the XXXX,
yes,
and then his lordship goes on to say that now that is something that might have been explained in the covering correspondence to the court, anticipating that it might be seen as an attempt to anonymity without making the requisite application, but apparently no such issues were anticipated or addressed.
Now these are two elements in quite a long judgment. So how do you challenge the decision, the judgment overall? I mean, do you say these are preponderant, or given? How does that fit? How do they fit in?
These are factors that should not have been taken into account by the learned judge in reaching his judgment.
Why not? I mean, it's absolutely standard form. particularly if you're up against a deadline, to keep your opponent informed. It's part of the overriding objective of cooperation. And what the judge is saying here is not that this is a formal part of a Denton and White analysis, but it's indicative of an extraordinarily relaxed attitude, I think is the phrase he uses, to the situation in which you found yourselves.
Well, turning to the issue of the unsealed application notice, your Lordship is right in observing that there is no requirement in the CPR to serve an unsealed application notice. And it would, quite frankly, be extraordinary if there was such a requirement. And I appreciate your Lordship's analysis is, well, that falls within the broad rubric of cooperation within between the parties. But essentially, his Lordship appears to be not characterising that as cooperation between the parties, but essentially saying no unsealed application was served on the respondent. But there is no requirement to serve an unsealed application.
But if you had served an unsealed application on the respondents, you would be standing there and saying, look, in the overall balance of Denton and White, it really doesn't matter because they had the unsealed order. And that would be a strong point in your favour. So why isn't the judge entitled to take that into account?
I'm not sure I necessarily would, my Lord, because just because an unsealed application notice has been served on the other party, the other party would be quite within its rights to say, well, yes, but this isn't a sealed application notice. Has it been filed? Has it been chased up?
To which the answer would be, yes, it has. I think in your case, no, it hasn't. It hasn't been chased up. But we're waiting for the court to issue it.
The difficulty, my Lord, is that effectively what this is being elevated into, in my submission, is an expectation that unsealed application notices are served on the opposing party. And that's effectively an expectation on a party which is not expected in the rules, it's not an issued court application, so it doesn't have the strength of the court approving it and saying, well, we are agreeing to issue it. There could be a myriad of reasons why a court may not agree to that. But effectively, to criticise a party, to say, well, you haven't served an unsealed application form, in my respectful submission, is not a factor that should be held against a party. And I've searched assiduously for any case law that suggests that there is any such duty, and the closest I've been able to find is the court's approach to an unsealed claim form, in fact, an unsealed amended claim form. But of course, there is an important difference between a claim form and an application notice. As your Lordship's brother judge, Lord Justice Arnold, has pointed out, the rules are different for a claim form and other documents. But there is no case law to suggest that there is that duty or that expectation on a party.
So you read paragraph 62, you sort of reverse it and say that the judge there is setting out a principled expectation or duty to serve an unsealed, rather than just an observation that no steps have been taken to provide an unsealed application. Just setting out what had happened.
Well,
postulating what difference it might have made.
Yes.
As one of the factors or one of the points he's addressing.
Yes, in my submission, he goes further than merely make an observation in the second half of paragraph 62. And he goes on to say it might result in the defendants taking a different attitude to the defaults, for example, prior to the application for a declaration.
Yes, right. Okay.
So my final submission, my Lord, if I may, is just to return to Denton and White and the approach of this court to contested relief from sanctions applications.
Yes.
And it's page 138 of the authorities bundle.
Yes.
The top of that page, their lordships, Lord Dyson, and as he then was, Lord Justice Foss. At the end of paragraph 36, the second line of page 138, the promptness of the application. Again, I won't trouble your lordships with that.
Sorry, wait a minute. Where are you?
So paragraph 36, which is the tail end of which is at the top of...
Paragraph, say it again.
36.
36, got it, thank you.
So it's
yes.
The relevant part is the top of page 38.
Right.
And the second line there talks about the promptness of the application.
Right, okay.
And then paragraph 37, the lordships talk about the difficulty following the Mitchell case with an unduly draconian approach being taken.
Yes.
Then there's a heading halfway down that page by capital E, satellite litigation and non-cooperation.
Yes.
And your lordships will no doubt be familiar with paragraphs 39 to 44.
Yes.
The concern from the courts about non-cooperation between parties.
Yes.
Parties opportunistically and unreasonably opposing application.
Encouraged by, as we were seeing by the Mitchell decision.
Indeed, and that
yes.
parties will obtain a windfall strikeout or other litigation advantage. And then the end of paragraph 41, returning to the issue of the 14 days or the 3 days or the 28 days. This is, in fact, what this court has said in relation to that. So the second half of paragraph 41, parties should agree that relief from sanctions be granted without the need for further costs to be expended in satellite litigation. Apologies, I should start from the beginning of that sentence. In a case where A, the failure can be seen to be neither serious nor significant, B, where a good reason is demonstrated, or C, where it is otherwise obvious that relief from sanctions is appropriate, parties should agree that relief from sanctions be granted without the need for further costs to be expended in satellite litigation. The party should, in any event, and those words in any event, I suggest would suggest that even were the ABC in the previous sentence not to apply, the party should in any event be ready to agree limited but reasonable extensions of time up to 28 days.
But you never asked for an extension?
No.
That seems to me to be significantly damaging to your position. Set out in Denton exactly how a party which finds itself in difficulty should act and how the opposing party should react, and you didn't do it. Am I wrong to see it in that way?
Well, I'm going to check the correspondence in detail. My recollection, I'm sure I'll be corrected if I get this wrong, is that a consent to relief was requested to try and avoid an application being made.
But that was after the event.
That was after the event.
You didn't ask for any extension of time before the deadline has expired.
Not as far as I recall, my lord. And again, I'll check the correspondence because there was quite a lot. But effectively, yes, I do take the point about the difference between a post hoc versus a seeking an extension. So there's a reference to 28 days there. Then paragraph 42 should be very much the exceptional case where contested application for relief from sanctions is necessary. And then the top of page 139, because the parties should work together to make sure that in all but the most serious cases, satellite litigation is avoided even where breach has occurred. And then paragraph 43, the court will be more ready in the future to penalise opportunism, talks about cost sanctions and indemnity costs. So, in conclusion, my lords, effectively, my submissions are that the learned judge fell into error in his approach to the deemed date of service being capable of being rebutted by personal service in relation to the claim form. The learned judge fell into error in his approach to prompt or promptly, and fell into error with an expectation on the appellant to serve a unsealed application notice. Essentially, these were factors that the learned judge either should not have taken into account or took into account incorrectly. Unless I can assist any further.
I'm just going to rise for a couple of minutes.
I've got the correspondence.
Yeah,
I'll show you. I don't think it helps you.
I mean, I didn't stick it all into the court bundle.
I always get a lot of boards that you say, in the loo. Such a sleep. Would you like some water?
No, I'm good. I'll just knock it all over the place.
Yeah, that's everything I've done. Yes, got that one, yeah. Yes, yeah.
Can't tell you right now because I'll have to speak to you probably. I'm just a little bit busy right now. Alright.
Yes, thank you very much, Mr. Van Dellum. We needn't trouble you, Mr. Brayley. The appeal will be dismissed, but our judgment will be reserved, or judgments will be reserved and provided in draft in the usual way. And it's important, obviously, that the draft judgment is only used for the limited purposes for which it is provided, because if you use it outside those limited purposes, it's potentially contempt of court. We would anticipate that once you receive the draft, you will be able to agree a draft order, but if there are any outstanding issues, we will deal with those, including costs. We will deal with those, if necessary, on paper with short written submissions from each side.
Thank you, my lord. Your lordship has referred to the letter from RPC who acted
Yes.
for the
Yes.
respondent, so it's likely that some form of brief written submissions on costs will...
Well, I thought they said no, they weren't seeking costs and they didn't want an order against them. Wasn't that what it was?
My apologies, your lordship is absolutely right. I anticipate there may be short written submissions between myself
So
and
I anticipate the only issue as to costs was between the two parties represented here today.
Yes,
Yeah.
and I suspect there will be short written submissions on
Right.
costs, my lord.
Yes.
My
Yes?
lord, the only other issue that we would wish to raise is the cars, which is why we're ultimately here. I understand that we're not allowed to sell the vehicles at the moment pending determination of this appeal.
Yes.
Obviously, you've indicated, well, I think you have dismissed the appeal, but obviously subject to reserved judgment. I was wondering where
Exactly.
that
And
leaves me.
That will simply provide the reasons.
Yes, so
But I think also you need to wait for the judgment to get the order, and it won't be until you get the order that the stay and everything else will be lifted. So I think the stay implemented by, was it Lord Justice Coulson's order, remains until you've got the judgment and the order has been approved. I think that's the better way of dealing with it.
Understood.
Thank you.
I'm sure you will.
Yes.
I just can't think of any cases. I think
That's the Supreme Court knowledge.
no. Well, it came down to the judge's discretion, really, and whether they exercise it properly. And I think at this level, I can't imagine. Well, Claimant's had a go. I'd like to see you in.
No, yeah. But I mean, it's not the sort of case that the Supreme Court. I mean, they've been discouraged from dealing with CPR points.
Yeah.
And these are all CPR points. So I just can't.
I mean, actually, companies etc. I appreciate there's two different entities, but he's sort of shooting himself in the foot by letting this run on because their value of the vehicles, well, it depends actually, they don't necessarily diminish, do they? They get older sometimes.
Well,
But you've got storage charges, right?
Yeah, they've been sitting in storage for.
Sorry, I'd say my.
So they've been sitting in storage for 2 years and 3 months.
Yep.
I mean, it's going to be.
Well, they need servicing. I anticipate the answer. I can't remember. I owe you